Hello, I'm Tom Gilbart.
And hello, I'm James Hurd. This is the fourth video in the 9 St John Street Employment Insight series.
And the idea of these videos is to help you all get to grips with some of the employment law issues which are arising or which might arise as a result of the COVID-19 crisis. We as a Chambers have had solicitors and clients contacting us, sending in their questions, and we've chosen a few of those issues which have been raised to cover in this video today.
So welcome to 9 St John Street Employment Law Insights. Before we start, please be aware of the terms and conditions. What we say in this video is covered by the disclaimer, which you can see on your screen now. We'll show this disclaimer again at the end of this presentation. As always, if there's something specific that the employment team can help you with, please contact Chambers and get in touch to us by phone or by email. The first thing that we need to mention, the first thing we need to mention is that there has been some breaking news, and that is that the government announced amendments to the job retention scheme yesterday on the 15th of April. The first thing is that we're also now aware, in relation to some of the dates, that the HMRC told the Parliamentary Select Committee that the online portal which you're using for reclaiming monies under the furlough scheme will open on the 20th of April, and the first reimbursement should be made by the 30th of April.
Also yesterday, what the Treasury did was to issue a direction to HMRC. That's under the powers which they've been given under the Coronavirus Act 2020, and that contains authority and instructions for making payments under the job retention scheme. And the headline, the most important thing to get across, is that employees who were employed on the 19th of March 2020, before it had been the 28th of February, they are now eligible for furlough, provided that the employer had submitted real-time information payroll data by that date.
There are some other changes which you should be aware of as well. In order to claim furlough, both employers and employees must have agreed in writing that the employee will cease all work, and this can be done by email. This is significant because it is a change from the previous guidance, which only said that written notification was required to employees. The new guidance provides that written agreement is required, and employers and employees should check the documentation that they have to make sure they are now eligible for the scheme and make sure they have a written agreement in place.
The scheme isn't limited to those employees who would otherwise be made redundant. It applies to anyone who's been furloughed, quote, by reason of circumstances as a result of coronavirus or coronavirus disease. That is broad enough to include people who have childcare or caring responsibilities, or people who are shielding.
The other thing to be aware of is that the amount of salary which we're talking about when you look at the amount that we're claiming, and further guidance has been given on the definition in respect of that, and you must disregard anything which isn't regarded as regular salary or wages. That includes disregarding any performance-related bonus or discretionary bonus, such as tips or conditional payments, where a particular threshold has to be met, and any other non-financial benefits.
The employer can claim for earnings which it reasonably expects to be paid to the employee, and that would seem to include deferred earnings, deferred until the scheme pays out, provided they're not conditional on the scheme paying out. So that's a summary of some of the breaking news from yesterday. If you want guidance in other parts of the job retention scheme, then there are already videos up from 9 St John Street, which you can find either on our website, www.9sjs.com, or also on YouTube, LinkedIn, Twitter, and other forms of social media. So away from the breaking news, what we wanted to do was to go through, as we say, some of the issues that have been raised with us by solicitors and clients. So the first one is a question for James to deal with. And what's been covered quite extensively is that employees placed on furlough must be furloughed for a minimum period of 3 weeks. But a question we've received is what happens if you have an employee whose employment is due to be terminated and their termination date is less than 3 weeks away? Can they still be furloughed?
Okay, so thanks for that, Tom. So as we've already said, there's a minimum furlough period of 3 consecutive weeks. When you return to work, you must be taken off furlough after that period. Employees can be furloughed for multiple times, but each separate instance of furlough must be for a minimum period of 3 consecutive weeks. Therefore, if you have an employee who's not already been furloughed and is due to leave your employment on any date prior to the 7th of May, bear in mind we're recording this on the 16th of April, you could not take advantage of the scheme. And the only way to get around that, if you're an employee that's already serving notice, would be for the employer and the employee to agree a variation in the notice period to a date which was in excess of 3 weeks to allow you to use the job retention scheme to place the employee on furlough for any period of 3 weeks or longer prior to the termination date.
So what's the situation if we've got an employee on a fixed term contract?
Okay, so the guidance is quite specific and does provide for what should happen in the context of a fixed term contract. There's no problem with the contract being renewed or extended during the furlough period without breaking the terms of the scheme. And where a fixed term employee's contract ends because it's not extended or renewed, you will no longer be able to claim the grant for them. But there's no reason, as far as I can see, as a result of the guidance, why an employee cannot extend the fixed term in the normal way and then furlough the employee, as I say, as long as there is a minimum period of 3 weeks.
Okay. Another inquiry which we've received is whether an employer can re-employ someone just for the purpose of furloughing them to make sure that person receives an income. It's right to say this question and the things that come from it raises quite a few issues, so I'm pleased to say it's James dealing with it rather than me. James.
Thanks, Tom. So as we've said previously, there's been some changes that have been announced in relation to the dates in the job retention scheme, and this is highly relevant. So under the job retention scheme, an employee can only claim reimbursement for employees who are on PAYE. That was originally the 28th of February, and that has now been amended until on the 15th of March to the 19th of March 2020. So that's the key date. Any employee who was on payroll before the 19th of March and an RT1 submission to HMRC for payroll has been submitted to them is now eligible and now covered under the scheme. That, of course, means that you can claim for up to 80% of the salary, a period of up to £2,500 based on the last pay round prior to the 19th of March and no longer the 28th of February. Now, the problem with that is it places any employee who starts a new job after the 19th of March in a very difficult position, as the new employer cannot take advantage of the government's coronavirus job retention scheme. And if that business is facing financial difficulties through a lack of trading, it may mean the redundancy situation arises, and the employee in those circumstances could find themselves both not in the second job they've gone to and having left the first job that they went to. The issue is in those circumstances is is there a way that an employee can still access the government's job retention scheme by approaching their first employer, i.e. their pre the 19th of March employer, asking to be rehired, taken back on, and then being furloughed so they could receive at least some income, the 80% up to a maximum of £2,500. Now, there are all sorts of technical issues in relation to this which lawyers have raised. One concern is whether if an employer is to rehire in those circumstances, whether they be covered by the guidance, which says if you cannot maintain your current workforce because your operations have been severely affected by the coronavirus, you can furlough your employees. If you have an employee that's already left in those circumstances, of course, it's highly arguable they're not part of your current workforce. And it would seem rather artificial to say that you can't maintain that current workforce if all you're doing is to take advantage of the scheme, is taking somebody on in a position that perhaps you've already covered and then immediately placing them on furlough. However, the government scheme and the guidance is very explicit on this issue, and it says if you make employees redundant or they stop working for you on or after the 28th of February 2020, you can re-employ them, put them on furlough and claim for their wages through the scheme. This applies to employees that were made redundant and stopped working for you after the 28th of February, even if you don't re-employ them until the 19th of March. And of course, that date, as I've said now, has now changed. It is the 19th of March. So there are clearly circumstances where it is envisaged by the government that you will be able to approach your previous employer, have them take you back on, and you could still be eligible to claim monies from that. It's clear the scheme is not limited to redundancy. It means stopped working for you, which is broader than redundancy. That could cover resignation, it could cover ill health dismissals, and it could relate to conduct matters as well.
And just for extra authenticity there, we can hear your kids in the background just to prove you really are working from home for this video.
Yeah, I do apologise for that.
Mine will make an appearance later, I'm sure. So looking at the issues that come from that, what's the situation if you have an employee who also has another job?
Okay, so on the face of it, if you have more than one job, the circumstances are that you can still be covered under the scheme. If your employee has more than one employer, they can be furloughed for each job. Each job is separate and the cap applies to each employer individually. Employees can be furloughed in one job but still receive a furlough payment, but continue working for another employer and still receive their normal wages. Working for a different employer, of course, you do have to be slightly careful, because what the guidance says is if contractually allowed, your employees are permitted to work for another employer whilst they place them on furlough.
What's meant when they say contractually allowed there?
Well, there is some debate, as you can imagine, in relation to that. I mean, clearly some employees, you can envisage circumstances whereby they may be better off working for a second employer whilst being furloughed from their original position and receiving up to 80% of their salary, up to £2,500 a month. Now, there is some uncertainty about this because, of course, much will depend on what your individual contract of employment says in those circumstances. Some contracts of employment will have clauses in which prohibit you working for a second employer. Others will not have any such clauses in. Now, it's to be hoped that provisions in contracts could be varied by consent between the employer and the employee. So the employer puts you on furlough and allows you to go and work somewhere else in certain circumstances. But there's some uncertainty because the government guidance makes no distinction between those contracts which have such a clause in and those clauses which are varied by consent, either after the 28th of February or after the 19th of March, in accordance with the guidance yesterday. So the guidance is arguably wide enough, but we do need to have a bit more clarification from the government. But as we were saying before, the guidance is wide enough in those circumstances, such an individual on a fixed term contract which has expired, re-employ them to place them on furlough. But as I say, further guidance will be welcome in this area.
So if you have a situation where a previous employer does re-employ, what happens in relation to back pay?
Okay, so this again is another area where there is some areas of where we could have some further clarification. But the guidance says that claims can be backdated until the 1st of March, where employees have already been furloughed. My understanding is if you haven't yet already furloughed an employee, the backdating date would probably now be the 19th of March. Now, the issue was addressed explicitly by the Chancellor, and he made it clear that it was possible that you could re-employ employees and you could backdate their salary and their other benefits in order to take advantage of the scheme. But in order to place this in some context for you, what's really important to understand is how the job retention scheme works. The employer still pays the employee at the same contractual basis as they would have done previously, whether that's weekly, whether that's monthly, and the employer then seeks reimbursement of up to 80% of those monies from the government. This includes regular payments of wages, overtime, fees, compulsory commissions, but as we said at the outset of this video, excludes discretionary bonuses, tips, commission payments, and other non-monetary taxable benefits in mind. Of course, the net effect of that is that in order for an employer to take on an employee, they have to pay out those monies up front and then reclaim them back from the government. And whether they're prepared to do that, of course, is a different matter. But the dates are critical, and if you're an employer even if you're a re-employee, as I've said, there's no obligation upon you to backdate any more than there is any obligation on you to re-employ in the first place. That is going to be a matter of goodwill between employer and employee in the circumstances. So just to give you an example, if you have an employee who resigned with effect from the 30th of March, they're rehired on Monday the 20th of April, technically an employer could backdate their salary to the beginning of the month and claim 80%, but they're not required to do so. That backdating could extend to the 1st of March if you're already furloughed, but if not, then presumably till the 19th of March, but not before. And in case of an employee who'd left their previous employment earlier, say the 14th of February, then you couldn't backdate it that far back, only in the case of new employees being furloughed back to the 19th of March. Now, of course, much of this is going to depend on the big uncertainty that we all have, which is when the job retention scheme is going to come to an end. The minimum period of furlough we know is 3 weeks. If an employee is rehired, for example, on the 11th of May, and the scheme then ends on the 31st of May, as the government intends at present, but we all know there's a possibility it might be extended, then the employee would not be able to reclaim any monies paid to the employee, as the period of furlough will be less than 3 weeks. It's not clear, and further clarification is probably required on whether an employer could rehire on the 11th of May, backdate to the 19th of March, and then try and argue that was 3 weeks, and therefore will be sufficient to overcome the hurdle imposed by the scheme. One of the areas that further clarification will be very helpful on from the government.
All right, so dealing with another issue that might arise, termination payments. What's the situation with payments made on termination, redundancy payments, payments in lieu? If an employee wants to be re-employed and wants to take advantage of the job retention scheme, does the employee then lose those payments and have to repay them?
Okay, well, that's a very real issue, particularly for somebody obviously who's in financial difficulties. You may have received a statutory redundancy payment. You may have received some pay in lieu of notice. The employer may turn around to the employee, say, well, I'll take you back on, but in those circumstances, I want the redundancy payment back. Obviously, that puts the employee in a difficult position. Now, the simple legal answer is that there is no legal requirement for the monies to be repaid. That would be a matter of discretion and goodwill between the employer and the employee. It would simply be a matter for them to agree and to negotiate what happens in relation to any payments that have been made on termination. Now, if the employee is required to reimburse or offset the employer in respect of any of the termination payments as a condition of being re-employed, so say, for example, you had a £500 payment in lieu, one of the questions, of course, is does that get included? Does it count as pay as part of the 80% of regular pay, subject to the £2,500 that the employee will be able to reclaim? This is one of those issues which further clarification on would be welcome.
So if you're an employer watching this, what practicalities should you have in mind if you are thinking of re-employing someone? Okay,
so just to emphasise again, no compulsion on any employer to rehire. Like any other recruitment decision, though, an employer must be aware that that decision to either rehire or not to rehire could give rise to further claims in employment law at some point further down the line, and particular issues of discrimination would apply. So an employer who makes the decision to rehire some employees but not others might face themselves looking at an employment tribunal at some point further down the line if there's evidence that the reason why that employee was re-employed or not re-employed was one of the protected grounds under the Equality Act: sex, race, sexual orientation, age, disability, just to provide a few common examples. So be aware that all recruitment decisions in these circumstances still face a degree of scrutiny. The really practical guidance is if you're considering rehiring an employee, there needs to be a clear understanding between the employer and the employee. As we've said, what happens about back pay, what happens about any repayment of termination payments, and to what extent is the provision for backdating payments and benefits. Those issues need to be properly set out and probably recorded in writing between the parties to make sure that there is clear certainty between the parties as to the terms on which any employee has been rehired. And it's worth emphasising, of course, that once you've been taken on as an employee, you therefore are an employee, at least technically, beyond the terms of any furlough, and that obviously has legal implications in terms of any subsequent dismissals.
And the last thing that comes from this is, what does this all do to continuity of employment?
Again, it raises a very interesting and quite a thorny question. Continuity of employment is one of those very difficult areas of employment law. An employee's previous employment period may well still be relevant, and continuity of employment will be preserved if the gap between leaving the employment and being taken on is less than a week. And of course, that could give rise to claims for unfair dismissal in the future if that individual has 2 years continuous service. But that would not apply if the gap is more than a week, and that's one of the specific provisions in Section 212 of the Employment Rights Act applies. However, continuity of employment is a very complex area, and it's an issue upon which employers may want to take specialist legal advice depending on the specific circumstances of any individual case. One possible route that employers may want to consider is in any re-employment agreement limiting the period of re-employment to the length of the job retention scheme, in essence creating a fixed-term contract with the normal rights that come from having a fixed-term contract but due to expire on the end of the job retention scheme. That may be one solution that employers want to consider. Okay, well, that's enough from me on that subject. Another question which we've had that's come through, which Tom's going to deal with, is this. We have a clause in a furlough agreement that allows an employer to lay off the employee without pay if necessary after the furlough period has ended. Is that permissible? Is it risky, Tom? And what then could an employee claim?
Yeah, so this question is about whether a layoff clause can be added to an employment agreement after the furlough period. The first thing to mention is about layoff clauses themselves. They're increasingly unusual. They're still used in some industries, such as manufacturing. So it may well be that you have very few existing contracts of employment which have layoff clauses in them. If you do have a layoff clause in an employment contract, then you're not going to need the consent of the employee to place them on furlough leave, because that clause will let you do that already.
Yeah, I mean, it's just important to reiterate again that any furlough agreements need to be in writing, and employees need to cease all work, and there's guidance available on what should be included in those agreements.
What you have to keep in mind, if what you're considering doing is adding a clause to an employment agreement saying that you can be laid off in the future, the furlough scheme doesn't affect the basics of employment law. It doesn't give employers any new ability to disregard the principles of contract or statutory provisions. So adding a clause to a furlough agreement that the employer can lay off an employee after the furlough period would amount to a change to the employee's contract. And the law there is no different from any other circumstances. You would need the agreement of the employee to make that change.
Would there be a danger for any employer in those circumstances then who sought to impose such a layoff clause unilaterally in an employee's contract?
Yes. If you apply the general principles of employment law, it might give rise to a claim for constructive dismissal if there was no agreement. An employee could argue, probably would argue, that such a change was a fundamental breach of contract and they wouldn't be able to earn a living. And that's what they would cite as the fundamental breach. If an employee agrees to being laid off without pay in the future, then the employer and the employee can come to that agreement and amend the contract in the way that they usually would. But it isn't different to any other proposed change to an employment contract. There's clearly a significant risk in the absence of an agreement, and you should tread carefully.
Thank you. So another question which we've received, and one which we've struggled with to some extent, is quite a difficult question, is this. Will the current coronavirus shutdown provide a basis upon which contracts may terminate due to frustration? Tom, is this an issue which has been addressed anywhere in the guidance from the government?
It isn't addressed in the guidance, this doctrine of frustration. In simple terms, what frustration means as a principle is that a contract between two parties can be discharged when an unforeseen or unanticipated event means that a contract can no longer be performed. In other words, this event so radically alters what the parties are required to perform that they're released from their obligations. And if a contract is frustrated, then the contract is automatically terminated or voided by operation of the law. No party has to take a particular step to achieve that. And at first blush, it may seem that COVID-19, always described as unprecedented, is likely to mean that many employment contracts are terminated by frustration.
So do you see that circumstances may arise where the doctrine of frustration is applied very often in the employment law context? Is it likely to apply to COVID-19 in your view?
Well, it's a difficult question to answer because although at first blush it may seem that COVID-19 may lead to the frustration of contracts, frustration is actually quite a controversial subject, and it should be remembered, very fact specific. It's hard to be definitive in general terms in presenting this video. It's right to say that use of the concept of frustration has really fallen out of use in employment law, in large measure because it's been overtaken by the legislation, in particular statutory procedures for dismissal, the law of unfair dismissal, discrimination law, in particular the Equality Act.
So am I right in thinking that the test for frustration is quite high?
Yes, the test is strict, and the threshold for establishing frustration is a high bar to pass. Really what's being asked is whether the situation we face now with COVID-19 means the contract could not be performed, and that is a high test, as I say. It's not enough that the performance of the employment contract has become more difficult or been delayed or become more expensive. It's something higher than that.
What sort of factors do you think might come into play?
Well, the chief one, if frustration is going to be considered, is how long this situation is going to continue for. And really, we don't know. There is going to be a difference in terms of any legal argument about frustration between a period of 3 or 4 weeks and a period of 3 or 4 months or longer.
What effect do you think the job retention scheme itself may have in this context? Could it be argued that an employee who's been furloughed, that this allows the individual contract of employment to continue, and hence the contract isn't frustrated?
Well, that's an argument which an employee might be able to use if they otherwise qualified for the JRS and could be furloughed, but obviously it won't apply to anyone who's not covered by the scheme. Another factor to bear in mind in assessing whether a contract might be frustrated is whether the event is beyond what was contemplated by the parties when they entered into the contract. Now, it may be that the terms of the employment contract could have, when they're properly analysed, provisions for circumstances such as these, and therefore it can't be said, when one looks at the detail of that particular contract, that the contract is frustrated. So again, these matters are all very fact specific.
I mean, could employers and employees really have seen this coming? We live, as you say, in such unprecedented times.
Well, it is unusual, but there are contracts which have within them clauses dealing with force majeure. So they will be particularly contracts for executives. But what that means in basic terms is that the contract recognises that its terms may cease to have effect or have a different effect when there are superior forces beyond the control of the parties, beyond the control of the employer and the employee, which would affect performance of the contract. Now, that type of term may well come into play in this crisis. If there is that type of superior force clause, which deals with the issues which we face now as part of the COVID-19 situation, then the doctrine of frustration, which we're discussing, wouldn't apply because the parties have contemplated those issues when they entered into the contract by having this superior force clause. But if that clause is vague, if it's inadequate in some way, then it may still be possible to say that the contract is frustrated, but close attention again has to be paid to the detail of a particular contract.
So would a fair summary be to say that any employer thinking about seeking to rely on frustration should proceed with extreme caution and obtain specialist advice before they act?
Yes, that's a very fair summary. There's a strict test. The particular facts of a particular case and a particular contract are vitally important. So you need to pay very close attention to what's been said of that contract of employment and pay very close attention to the particular circumstances of a particular case. So it isn't possible now to advise that the doctrine of frustration will or will not apply. It doesn't apply generally across the board, that analysis. It's an unusually used argument. It's a high bar to pass and there are numerous uncertainties. and a lot will depend upon how long the lockdown lasts for. Parties should be very careful proceeding with this argument, and they should, of course, obtain specialist employment law advice specific to their situation.
That's great. Thank you. Thank you very much.
So those are the issues that we're going to deal with in this video today.
You can continue to email us. Please do, with any questions that you've got, at employmentinsights@9sjs.com. You can contact members of the team for specific advice. You can read about the team at www.9sjs.com/employment, and you can contact us in chambers.
Now we're going to just show the disclaimer again before the video ends, but of course in the meantime, before the next Employment Insights video, we hope you all look after yourselves and get through the crisis as best you can, and we'll see you on the next video.
Thank you. Goodbye.